The fight over President Donald Trump's financial documents, and in particular his tax returns for him and his related business entities, continues in New York County Criminal Court. How do we get to criminal court? What's going on with these requests? And more importantly, what is President Trump doing to protect the disclosure of these documents to the extent legally possible in the court system right now? Let's have a chat about it. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking about President Trump attempting to resist a criminal grand jury subpoena in the request for production of his personal and business financial documents, and importantly, for him at least, his tax returns. Now, you may have heard some different stuff about this story. It's been going on for quite a while because it actually started outside of the criminal court and then was sort of incorporated into a not quite existent criminal case. And we're going to talk about how all of that factors into the request for these documents and the resistance to the request for those documents that is going on right now. So, first, the request for Trump's financial documents came from the House Oversight Committee and the House Ways and Means Committee. Trump, of course, attempted to resist the disclosure by filing federal lawsuits stating that these requests were improper of the President of the United States. And then a parallel case arose in the New York County Criminal Court. Right? So not a federal court, and in the New York County Criminal Court, and in particular, the subpoena was sent to not President Trump for production of his own documents, but rather to his accounting firm so that they would present documents as the custodian of those documents and present them on his behalf. He challenged this back in September of 2019, stating that the president was actually immune to a grand jury subpoena or a criminal subpoena in this context. Now, the lower court, the appellate court, and the Supreme Court all disagreed that President Donald Trump would be immune from such a request in a criminal matter. However, interestingly, they did agree that the president was afforded some higher level of protection or a higher duty of care in crafting the subpoena for the purpose of legislation. That was what was raised originally in the House Oversight and the Ways and Means Committee. They alleged that they needed to see Donald Trump's personal and business tax records for the purposes of legislating. And Trump challenged that, stating they didn't give any actual legislative purpose behind this. There's no real, tangible, or obvious way that this would benefit legislation, to the point that they needed his specific information to craft whatever legislation they had in mind. They said that they could get the data that they needed in other places, and that the Congress or the congressional committees had not shown a particularized need for his individual documents. The Supreme Court agreed on that, but like I said, they disagreed in the criminal matter, because the only assertion President Donald Trump made in the criminal matter was that the president was generally immune to subpoenas in a criminal matter, or at least subpoenas of this nature. However, in rejecting that argument, they did remand it back to the lower courts and said that Donald Trump could explore other remedies to remove his liability or burden under this subpoena, that he could resist it in other ways, the same way that just about anybody can resist a subpoena. And he has done so on two major grounds. First, and most importantly, is the idea of overbreadth, saying that these subpoenas are way larger than the purported investigation or even the jurisdictional ability of a New York County attorney. A New York County attorney is limited in scope to what he can investigate, and that is only to crimes that fall under New York state law and either occur in or have the results felt in New York City limits, where New York County actually is. That is an important jurisdictional limitation. If a crime is alleged to have occurred outside of that jurisdiction, then the New York County attorney has no investigative authority and therefore cannot pursue a subpoena to get documents that would relate to something outside of that jurisdiction. Everything has to be tailored to achieve the investigative purpose within the jurisdictional bounds of the inquiring body. And again, in this case, we're talking about the New York County District Attorney in his investigative ability and in the grand jury process. So, President Donald Trump, like I said, is challenging that on overbreadth, and we're going to talk a little bit about why he's challenging it on overbreadth grounds, and then similarly, he's challenging it on bad faith grounds. And this is a little bit more of a narrative argument than the overbreadth argument. So we'll handle each of those in kind. First is the overbreadth argument. And here what I've got is their actual claims for relief from the document. If you want to see a full breakdown of documents like this, you'll have to catch up with me on one of my live streams, which happen generally every weeknight at 11 p.m. Central Time. That's when we're more likely to go over a full document, because this is 16 pages. It would take, at least an hour to go through in depth this entire document. And I'm trying to bring you a quick hit on the news. So we're just going to look at the summary of the claims for relief here. Count one of overbreadth. The subpoena seeks voluminous documents that have no relation to the grand jury's investigation and instead relate to topics and entities that far exceed the district attorney's jurisdiction under New York law. The subpoena covers a time frame far exceeding that of the grand jury's investigation. We talked a little bit about the geographical and legal limits of jurisdiction for the district attorney and the grand jury in general. But we didn't really talk about the time frame. Most criminal laws in the state of New York have a statute of limitation between 1 and 5 years, exceptions being things like capital murder offenses and maybe some sort of sexual assault related crimes. They're not investigating those sorts of things. In fact, they're investigating alleged financial crimes, and they have requested, possibly. They haven't really laid out the scope of what their investigation is after. And that's part of the problem as well, which we'll talk about in a minute. But they have requested over 10 years of documents from President Donald Trump. Well, on its face, that is overbroad. If you're getting 10 years of documents, you're exceeding the statute of limitations on the crimes that you would purportedly be investigating related to some sort of tax question that would require the tax documents, or in this case, the alleged payments to Michael Cohen, Donald Trump's attorney, for the purposes of paying off people like Stormy Daniels and other accusers. Those are some of the allegations that might be being investigated here. Those have a statute of limitations of 5 years, and therefore seeking 10 years of documentation is facially overbroad, and it's significantly burdensome, especially when you talk about what they're asking for. And if we were to go through the whole document, it actually shows you, but we're talking about 10 years of tax return and tax preparation information related to not only Donald Trump personally, but all of his trusts and other business entities. So we're talking about thousands and thousands and thousands of multiple page documents that would need to be produced in a very short order. That is significantly burdensome. It is also very intrusive into what are otherwise pretty personal or potentially even protected business affairs. So those are some of the concerns that Donald Trump is alleging, and saying that the overbreadth of the subpoena should invalidate it, and that if he wants documents related to an investigation, maybe he should narrow the scope of it to things he can actually investigate. The subpoena is overbroad, improperly tailored, and otherwise amounts to an arbitrary fishing expedition, and accordingly, the subpoena amounts to harassment of the president in violation of his legal rights, including those held under the Article 2 of the Constitution. So that is, again, getting into the more narrative aspects of the overbreadth. This is why he's created a subpoena that's overbroad. But the underlying legal pinnings are this exceeds the jurisdiction of not only the attorney and the grand jury, but It exceeds the jurisdiction of New York State itself. That's what's alleged in the in the broader aspect of the document. The next count is bad faith. In response to a dispute over whether the president's tax returns were encompassed by a grand jury subpoena, District Attorney photocopied a sweeping congressional demand and issued it to the president's records custodian. So this is laid out higher up in the text, but basically they do a comparison of the original congressional demand for Donald Trump's financial records and then this particular demand created by the district attorney, and it's an almost direct copy of not only the language, but each of the individual issues and each of the document requests that are in there. Why does this matter? Well, it matters because, one, the grand jury would be investigating something wholly different if they were actually investigating anything at all, right? The purported purpose of the congressional subpoena was for the purposes of legislation. The grand jury subpoena must be in pursuit of a criminal investigation. So we right now have a incongruent purpose for the two subpoenas, but they are identical, which means that things that might be valid or might be facially relevant, like 10 years of tax returns if they're going to create tax policy or something like that, would be valid under a congressional subpoena, but they would not be valid in the terms of a criminal subpoena. So in photocopying them, not only is he going overbroad, but it looks like a measure of bad faith. It looks like when the other case was losing steam or losing faith from the courts, that this came in as an alternative means to achieve the same purpose, and that purpose is alleged to be improper. That purpose is alleged to be a public disclosure of otherwise personal documents of the President of the United States for the purposes of harassing him, is what he's alleging. So again, this is a much more narrative argument than the overbreadth argument, which is a little bit more technical. So the district attorney lacked a good faith basis to believe that the subpoena is tailored to the grand jury's investigation. Rather, the district attorney has admitted that the subpoena is not based on or tied to any potential violations of New York law. And he has done that. The district attorney actually came out and said that he copied the subpoena from the congressional committees, but he said that he did it for efficiency for the purpose of Mazars, the record custodian, Donald Trump's tax and accounting firm. He has said that he's done it for efficiency on their part, since they were going to produce this stuff for the Congress anyway. We'll just give the same request. But that's not how criminal subpoenas work. In fact, it's the opposite of how criminal subpoenas work. There is no convenient method of producing documents in a criminal subpoena when you are potentially an accused party or when you are under investigation. It is entirely burdensome and intrusive. It's the state reaching into the private affairs of a person. So to suggest that you're doing it for their benefit, making it broader, is let's just say there's a disconnect going on there. Whether the district attorney photocopied a congressional subpoena for political reasons, for efficiency reasons, or for both, he knowingly and intentionally issued a wildly overbroad subpoena for the president's records. It was issued in bad faith. Accordingly, the subpoena amounts to harassment of the president in violation of his legal rights. So, what is the outcome here? What's going to happen? Well, we'll have to see. We'll have to see. But the president has laid out, at least with some strong legal argument and with a lot of references to the Supreme Court's recent opinion in Trump versus Vance, which is where the Supreme Court determined that he was not immune to a subpoena but may raise other challenges. He used a lot of their language in this filing. If you were to explore it, you would see all of that language coming out. And in doing so, he's put forth a solid legal argument that this is overbroad and that this needs to at least be curtailed to narrow down the focus of the subpoena to be in line with a reasonable investigation of New York state law for violations that would have impact or have occurred in New York County, or rather in New York City limits. So whether or not the court will attempt to pare that down, or if they will just strike the subpoena and require a further subpoena that is more narrowly tailored, remains to be seen. It's entirely possible that the district attorney could simply withdraw his subpoena and attempt to reissue one in accordance with the court's rules and with state law. So that may be on the menu as well. We'll have to see, or we could see the lower courts, as they did before, allow the subpoena to go on and then have the challenge go back up through the Supreme Court, in which case we won't have an actual result on this until for another couple years, and potentially after Trump is out of office, depending on the election results in 2020. So that's where we stand right now on the president's defense of his personal and business financial records. He has asserted, for better or worse, a very good legal defense of why he should not respond to this particular subpoena. And that's an important thing to notice here, is that he is arguing in some respects that as the president, he's entitled to some more deference. But the arguments that he's using aren't really necessarily connected to him as president on the whole. These are the same types of protections that should be afforded to every citizen of the United States. And in my personal opinion, the fact that he keeps raising the specter of the presidency is to go ahead and just remind the court that there's a political motivation behind this subpoena that is not relevant at all to the criminal investigation. Rather than asserting special privileges of the president, he seems to be asserting more that I have these protections as every citizen does, and this argument is actually in the document. I have these protections as every citizen does. However, these subpoenas are coming out in the way that they are because I'm the president of the United States, and a political dissident or rival is attacking me based on that status. So that's what's going on here. I hope you guys found this informative. I'll be following along with this case, so watch out for other videos related to Trump's taxes as things develop and as things continue to come out, as we see what the district attorney's actions will be. If you found this video informative, if you like these short legal updates and education pieces, please hit like, subscribe, share this stuff, and leave a comment below telling me what you want to see, telling me what you loved or hated about the video, and I would love to read it. All right, guys, thanks for joining me. Have a good day. Peace. Peace.